I'm excited today to introduce our guest, who is an experienced attorney. She'll be speaking on a topic that is so vital to us in business, but often is neglected. In today's climate, with everything that's going on, contracts those are important. So we need to get our contracts in order. So my focus today is for Callan Soldavini to walk us through the world of agreements and why we need them, especially now. So a little bit about Callan. First of all, she's a public interest attorney. She is dedicated to helping those with unmet legal needs. She's represented clients in Kenya, Libya, Vietnam, after their fundamental human rights were violated. She teaches courses in ethics, business law. She teaches courses in corporate social responsibility and conflict resolution. So not only she is an attorney by day, she's teaching and she's doing a lot of stuff with the community in general. She worked as a transactional business attorney and a civil prosecutor. And now she's with the FCDL as an attorney at Legal Aid Services of Collier County. And she continues to advocate for underserved communities. Her goal is to promote community economic development and to stimulate growth in our community. So, and I personally have sought out Callan's counsel, and she has been great. And I'm just really happy to have her here because she is a phone call away literally from me. And here I bring her to you. So please join me in welcoming Callan Soldavini to our program. Callan, take it from here.
Hi, everybody. It's great to be here, and I absolutely love these topics because rather than scrambling to find an attorney after something has happened, my goal with this presentation is just to have some specific and basic principles that all small businesses should consider when dealing with contracts. So I'm going to share my screen and have a PowerPoint here. It will have my contact information. So if you have any questions or would like a copy of the presentation, please feel free to reach out to me. And then Sidoni, can you give me the thumbs up if you can see everything in the PowerPoint all right? Looks good. So I want to talk a little bit, build on what Sidoni mentioned about our FCDL program. FCDL stands for Florida Community Development Legal Team, and we have over 10 attorneys statewide. So I work particularly in Lee County and Broward County and Collier County. But if you're anywhere else in the state or know of anyone else in need of free legal resources, we service clients throughout the state. In order to receive these free services, our eligibility is that our clients must be low to moderate income business owners. Low to moderate income means up to 140% of the area median income. So for example, in Broward County, for a family of one, I think it's like $75,000, and for a family of four, it's closer to $90,000. So we have a really liberal threshold to be able to service our clients and provide free legal services. So we don't have individuals as clients. They're either going to be the small business, the business itself, and we also represent nonprofits. And the legal services we provide are, we can help you incorporate if you are a new business. We can help you trademark, draft or review partnership agreements and various contracts, leases, resolutions. If you need a client template agreement, if you have an agreement that someone's trying to present to you, even if you're not allowed to change it, which might happen with government contracts or commercial leases a lot, we can at least help you understand exactly what you're getting into. So really anything outside the courtroom, we help our small businesses with. And again, all our services are free of charge if the business is owned by low to moderate income business owners. So before I get into the nitty gritty, a quick disclaimer that all of the information in this presentation is intended to convey general information. So this is what applies generally. But if you have a specific legal need, you're encouraged to seek a qualified attorney or financial advisor for anything discussed in this program to meet your specific needs. So again, I'm going to discuss generally contract issues that face small businesses. And if you have questions that come up along the way, feel free to write them within the message center, and Sidoni will either interrupt me or I will answer those at the end of the presentation. So the 4 things I want to talk about today are a small business's internal operating document. Second, we'll move on to non-disclosure agreements. Third, we'll move on to non-compete agreements. And lastly, we'll talk about independent contractor agreements and how those differ from employment agreements. Then I'll just briefly talk about a few clauses, no matter what your contract is that you're drafting or reviewing, a few things that you just always want to look out for and make sure that are included. And before I really get into this, a lot of times my clients will come to me and say, you know what, I've been working with this individual or this business or this partner for years, and we have always had this understanding. And I have to bring the devastating news that while it's unethical for someone to promise something verbally, a lot of times if there's a written agreement, there's a clause in there that says if anything in this written agreement changes, it can only be changed in writing and not verbally. So it's really important, not what you understand with someone that you're entering a contractual relationship with, but what's actually down in writing. So I can't stress enough that it's really important to review those long, legal, tedious documents and make sure that what you need in that document is actually there and what you understand in your mind is actually what's on paper. So the first written document I want to talk about is an internal operating agreement. And if you have a business, especially if you have more than one person involved in your business, especially, you want to make sure you have this internal operating agreement. For a corporation, they're called your bylaws. For an LLC, they're called an operating agreement. And for a partnership, it's called a partnership agreement. So really, they're all the same thing, and it's an internal document, so it's not public. However, maybe a bank or if you're getting a loan might ask for it, but it's really going to detail how the business is managed, how the business is going to pay taxes, how profits and losses will be distributed, how much each owner has paid in, and any obligations that they have to pay more into the business to be involved in it, the duties and responsibilities of each owner, what voting rights are, what capital contributions are, etc. And if you think that you understand it, again, take the time to put pen to paper and write it down, particularly and really importantly if there's more than one owner. Because if you don't have an internal operating document, oftentimes Florida statute is going to fill in the blanks, and you'll be held to a standard or a law that you never intended to. For example, if you have a partnership and you put in 80% of the money and you do all of the work, and you have another partner and they come in, they help you once every other week, and you discuss it and you say that they're really only entitled to 20% of the profits because you put in 80% of your money and 80% of your time. Under Florida statute, the law is going to interpret a partnership agreement for you if you don't have one written down in place, and it will say that each partner splits the profits and losses 50-50. And that's absolutely not what you intended. And you'll say, Judge, but we talked about it over coffee several times, and this is what we said. But unless you can actually show that a judge that written document, what here would be called a partnership agreement, it's going to be very difficult to prove in a court of law. So making sure that you have that document that explains the operational and financial management of the company. Next, I want to talk about non-disclosure agreements, often referred to as NDAs. This is a legally enforceable contract between a person or a company that has confidential information of somehow and a person or entity to whom that confidential information is going to be disclosed. So if you think about all of the transactions you enter into your business, you're probably thinking, I have a lot of confidential information I share with people that I'm just in basic discussions with. To have an NDA, you don't have to have a formal business relationship. You can just be in the negotiation process. And especially before you enter, just negotiating, before you even have any idea that any kind of relationship will come out of it, an NDA is really vital. And the more details you can put into an NDA to define what the confidential information is, the more likely a court will enforce it and protect that confidential information. Most commonly, an NDA will be with employees because you want to, or independent contractors, because you want to prevent employees and independent contractors, those that work for you, from disclosing your confidential information to third parties, whether or not they're employed by you. So you can make it so your NDA lasts years or indefinitely beyond the time of the employment. It can also be, an NDA is vital with third parties. So not just your employees, but if you're negotiating to sell your business or buy another business or bring another vendor or party on board with your business, you want to have one with third parties. And the most common is when you're trying to facilitate a business deal while still protecting your confidential information. What's your client list? How do you come up with your pricing? What's the contact information for all of your vendors? What prices do they charge you? This is all confidential information that makes your business lucrative, and you don't want someone taking that information and sharing it with a competitor or using it to start their own business. So an NDA is really vital to protecting that information you've been working so hard for. Then there are non-compete agreements. And non-compete agreements are agreements where an employee promises not to compete with an employer's business during the time of the employment and for a specified time after the employment ends. So during the employment and after, if you say 2 years, they can't compete with your business directly. I will note that this is a great document in theory, because who wants to have someone that they put all of this time and energy and money into train, leave them, and 2 months later go get a job with a competitor or start their own firm based on everything that you've taught them, because having a new employee is always difficult. The problem is in Florida. Florida is a very, very difficult state to enforce non-compete agreements in. So we want to make sure that it is as reasonable as possible. That's how the law is going to look at this. Is this document reasonable? And I have a quote in the bottom orange rectangle of Florida statute. This is the standard that judges will look at a non-compete agreement. It's difficult to enforce, so the court you have to show the court, quote, reasonably necessary to protect the legitimate business interest of the party trying to enforce it. So you probably can't say that the employee or independent contractor that you have can't work within the state of Florida for a period of 5 years. That's extremely unreasonable. It's going to make it extremely difficult for this individual to continue utilizing these skills in the same home and the same life that they're living. It's going to be unreasonable. It would be more reasonable to say they couldn't do it within a 5-mile range for a period of 2 years. So it seems really like a great document, but it really does have to be reasonable at the end of the day. Generally, employees are not to work for the employer's competitors. So this is a great document to protect that. And they're not to solicit your customer, the employee's customers, for a specific period of time between the buyer and seller and the purchasing of an ongoing business. So yes, you can protect yourself, but you absolutely have to be reasonable under the circumstances. And the circumstances are going to change for each industry. 2 more points. The employer must show that it would be harmed in some way if the agreement was not enforced. So it's probably whatever you're trying to get your employee or independent contractor to agree to, you have to be able to show to a judge that if they violated that term in some way, that you would be directly harmed in some way. Also, a reasonable time period and geography for a non-compete is vital. In the state of Florida, it's going to be very, very unlikely for a court to enforce a non-compete agreement that lasts more than 2 years. 1 year is much more reasonable, but it's extremely, if not the rarest thing, for a Florida judge to enforce one for over 2 years. So if someone has made you sign a non-compete, or you're having your employees or independent contractors sign one for 2.5 years, 3 years, that's not going to be enforceable. You want to think about the radius as well, because essentially, to be reasonable, the employee should still be able to reasonably continue to work under the terms of a non-compete agreement. Additionally, your competitors should not be hindered from hiring employees and independent contractors that leave your business within a reasonable amount of time. The point of law really is to encourage growth and economic benefits, and so that is why Florida statute is so strict about non-competes. They need to be as reasonable as possible, and if they're not unreasonable, a judge is going to refuse to enforce them. Next, we're going to talk about independent contractor agreements. And before we get, and then I did have a question, backtracking, I remember that someone had emailed about non-compete agreements, and they had asked if they can make a non-compete agreement with just employees, or can they also have one with independent contractors? Absolutely. Independent contractors function a lot like employees, and we'll, in the next slide, talk about how they don't. But yes, you can absolutely make your independent contractors sign non-compete agreements, with the caveat that it has to be reasonable. So having an independent contractor not be able to work in the sphere, in that business sphere that you're in, for 2 years, an employee, that makes more sense because they're full-time. The 2 years makes more sense, but for an independent contractor that might only be coming in once or twice a week, that could be different. So again, I have you look at, yes, they can apply to independent contractor agreements, or independent contractors, but make sure it's reasonable. And again, take a look at that language on the bottom orange rectangle. It has to be reasonably necessary to protect legitimate business interests. If it's not, or if it's really harming the employer independent contractor, or if it's harming your competitors to be able to find employees or independent contractors unreasonably, it's going to be too difficult for a judge to enforce it. Even if you negotiated it, you and your employee or independent contractor understood it, a judge will still throw it out.
And Callan, we have one more question.
Sure. This
is on NDAs. Are NDAs enforceable beyond 3 years after the separation in Florida?
Are they enforceable beyond 3 years? Yes. They generally, unless there's generally, yes, they should be enforceable for a long period of time. And particularly, what it will really matter is if for some reason the information has become public, someone else has found out, or it's just found out through common chains of interaction, that's probably not going to be something that can be confidential for that long, but generally confidential information in business can, you can have an NDA last for 3 years.
Okay.
And then moving on to independent contractor agreements. But before I get into the agreement, I just want to point out a couple of things that independent contractors are not and how they differ from employees. It's important to know if you are not an employee of a company, but instead working as a freelancer or self-employed worker, that's a different legal and IRS categorization. So independent contractors have a significant difference from employees. And I bolded some examples here. Independent contractors pay their own taxes, so it's not up to their employer. Independent contractors are not eligible for company benefits. So you're not able to get health insurance or retirement plans. They're not able to receive unemployment benefits. Independent contractors are not subject to laws regarding discrimination, wages, or hours worked. So they can work till 10 o'clock at night. They can work on the weekends. They are not going to get overtime. They can, they don't have to worry about being somewhere at a specific time, absent it being necessary for a project or something, but really independent contractors get this freedom to work when they want. Of course, they don't get a lot of these other benefits, and they're also able typically to have other employers. Independent contractors are typically not trained. They're usually hired because they already have the expertise the employer needs. And again, they set their own times. They decide how they're going to complete the job. And oftentimes, especially right now, will be working from home. So those are some core differences from an employee. And you want to make sure if you're hiring someone that you consider an independent contractor, you continually treat them as one. It's a little iffy to say you have to be here from 9 to 5, you have to do your job this way, and if you start creating too many restrictions and start sounding like an employer, then the law, if something were to happen, the law might actually treat that individual as an employee, not an independent contractor. So you want to make sure that you allow the independent contractor to actually function as one, so you don't get in any issues where IRS, or if you need to enforce the agreement in a court of law, isn't saying, wait, this actually looks more like an employee rather than an independent contractor. So in an independent contractor agreement, I often have clients think because they're not employees that the agreement isn't as important. It is equally as important as an employment agreement. So I have a few terms that to make sure are included in your independent contractor agreements. First is who the parties are. That seems really obvious, but if I'm going to enter into an agreement with someone and hire them as an independent contractor, I'm really not hiring them individually. They might have a business that they run. They're working as an independent contractor for various businesses for. So I don't want to enter into the name John Smith. I want to enter into ABC LLC, John Smith's limited liability company, because who you're entering it with and the names you're writing down, it may seem so obvious. Of course, John Smith owns ABC LLC. But if it's not clear in the written document and something happens and you need to enforce it, it looks like you're actually entering into a contract with the individual, and there's a whole slew of issues that come with that. So make sure that you're entering into it with your business name and with the independent contractor's business name if they have one. Next is detailing the purpose of the relationship. So exactly what is this independent contractor supposed to do? Are they focusing on a specific project? Are they working 2-3 days a week, or 30 hours a week, 20 hours a week? Is this a one-time thing, or is this recurring several times? And making sure that that is clear. It should be important to include a timeline. When does this legal relationship end? What are the payment terms? Is it payment by hour, or will the independent contractor invoice you? How long until those invoices are paid? Are they able to get any kind of reimbursements? All of that should be detailed so that when a payment issue comes up, you can look back to the document and that will have the answers in it and no one's fighting. What are the party responsibilities? Who's doing what? What's expected of the independent contractor is really important to lay out before, again, someone gets into a conflict wondering who's supposed to do what. And I always like to include insurance. Who is in charge of paying for insurance for an independent contractor should be detailed. How do you terminate the independent contractor agreement? Is it a certain date? Is it after a certain event? Is it going to just automatically be renewed until you terminate it? Is it going to be for cause? If, does the independent contractor have to do something wrong, like not turn in assignments on time? Or can you terminate the independent contractor agreement for any reason? Maybe, and COVID has impacted us all, and this has required a lot of us to let people go. Is that something that's contemplated in your independent contractor agreement? And then, as we discussed earlier, keeping a non-disclosure agreement and provisions within your independent contractor agreement and non-compete language. So always making sure those are really in any employment agreements and the NDA, even with third parties that you talk to about your business. And finally, I want to go through a couple of common clauses to include in a contract, really just any contract. First, termination. Spell out the rights for each party to terminate, as I just mentioned with the independent contractor agreements. Can you terminate it for cause or not for cause? For any reason you can end that relationship. Is it a certain date, a certain event? Making sure that's spelled out. I know I'm sure a lot of you have unfortunately become familiar with force majeure, which is a clause in a contract that relieves both parties from liability when an act of God or some kind of circumstances beyond the party's control occurs. So before COVID in Florida, we always thought about hurricanes and how hurricanes can stop an event from happening in the business, but it's not really anybody's fault. So contemplating how to treat that, how to treat deposits. Are we going to let someone keep them? Are they going to be required to carry that deposit over until next year? Whatever it may be. Sometimes we also thought about terrorist attacks. If a terrorist attack could close down the economy or business for several days. But now we've really seen it come to light where businesses were forced to close for several months. Some still are. And so now lawyers across the country have made sure to include in all of their force majeure clauses national pandemics and COVID. The thing about force majeure clause, they need to be really specific. So you may have looked in your contract and thought, oh, I have something in here that says, you know, there's bad weather that we can each be relieved of the obligations under this agreement. In Florida, judges are really harsh. It needs to be really specific and enlist a specific event for a court to enforce it. And it's really hard. We don't have a crystal ball, and no one anticipated anything like COVID-19 happening. So a lot of times, even if someone spent tens of thousands of dollars at fancy law firms drafting these agreements, they'd look back and nothing said anything about national pandemics. So really, a lot of people were really hurt by this. And really, now it's important because we do see that a second wave is potential. Reclosures of businesses are happening. Make sure that any new contracts that you're having specifically mention COVID or related diseases to COVID. I also like to include the words national pandemic, meaning something that our nation has declared a health emergency. And I also include any national emergencies, which would include, unfortunately, terrorist-related events, because that is something that could also impact businesses. A third clause I always recommend, third-party terms and conditions. If you're working with a third party that imposes terms and conditions on you, and you want to make sure that you impose that on your client, then you want to include the relevant portions of those terms and conditions and attach it to your agreement that you have the client that you're working with sign, and say that you're held to those terms and conditions, and they are also held to all of those relevant and same terms and conditions. Fourth, I always recommend, or generally recommend, including an attorney's fees provision. Someone can be 100% legally right, and the other party in the contract can still devastate your life and your business by filing a lawsuit against you, even if you are 100% in the right. And you'll have to, in American jurisprudence, every litigant pays for themselves unless noted otherwise, or unless the behavior is really bad. So if someone wants to mess with you and file a lawsuit for something contained in your contract, even if you are 100% right and they are 100% wrong, you will still have to hire an attorney to represent you, unless you're going to represent yourself, which is not recommended. You will have to pay court filing fees. You'll have to file documents that have several thousands of dollars worth of cost to them. So if you know you're someone that lives by their word, that understands the contract that you have, then you probably want to insert an attorney's fees provision. And that can look like something that says, quote, the prevailing party shall have the right to collect from the other party its reasonable costs and necessary disbursements and attorney's fees incurred in enforcing this agreement. So that means if you are in the right and the other party files a lawsuit and that party loses, then you can hand your attorney's fees bills over to the losing party and require them to pay it. It's a huge protection. And if the person is wrong, it prevents them from filing a frivolous lawsuit. Finally, I like to include venue and jurisdiction. That means that you want to make sure that if there's whatever laws apply to the contract, and if there's anything that has to be litigated in court, you want to make sure that you pick what laws apply and what court you go to. So a venue and jurisdiction clause would look like, quote, the jurisdiction of any proceeding between the parties arising out of or with respect to this agreement shall be in a court of competent jurisdiction in the state of Florida, and venue shall be in Broward County. Each party shall be subject to the personal jurisdiction of the courts of the state of Florida. It's pretty much a waiver saying, I don't care where you do business right now, or I don't care where you move, I don't care where you take the things I sell you and sell them, whatever it may be. It's a borderless country in many ways, especially when it comes to online sales. So making sure that there's a venue and jurisdiction to say, this is where I live, and if I have to enforce this in a court of law, we're going to do it next to my house, not up in New York where your headquarters are. And that's takes a lot of money and time to litigate that if that wasn't already established. So that is it. Those are really what I like to say especially for our first webinar. These are the contracts I like to see my small businesses have, and those are the terms I like them to have in just any contract. So I'd love to take any questions you have. And again, my contact information is up on the screen if you'd like a copy of the PowerPoint, or if you're interested in our free legal representation, and all of the business owners are low to moderate income, meaning up to 140%. We absolutely love serving our small business entrepreneurs because they clearly are here giving your lunch break, you're hardworking, and you have a dream, and we'd love to do what we can to make that dream come true.
Okay, well, thank you, Kellen. We do have a few other questions. I'll just go ahead and start so you can address them. The first question is, we are a dance company. If our dancers use our choreographer without our consent outside our event, how can the non-compete help us and protect our intellectual property?
So if there's not something written down for the choreographer stating that they can't, take clients from your business, you want to make sure that there's something in place. If there is something in place and you have had him or her already sign a non-compete, then you want to remind them of that non-compete and say that this is enforceable in a court of law and we need to do this to protect our business. You are the one paying for rent, you are the one paying for office management, staffing people to make sure this business runs. It's not really fair for someone to come in and just take clients away without having to do all of that work. So just reminding them of that kindly, because sometimes people certainly aren't really familiar with it, what a non-compete is, or maybe the harm they're causing your business, and just say, remind them of that and let them know, look at this non-compete, these are our rights. Of course, we don't want to enforce them, but we do have to protect our business, and we hope that you comply so we don't have to litigate this issue.
Okay, great. Thank you. We have another one. Can we give a government entity our contract instead of signing theirs? Often we sign their agreements because we need the job and don't want to complicate things.
That is a great question. As everyone here knows, there's always an agreement we face in our lifetime that we probably aren't able to negotiate. For example, when we lease a car, or commercial lease, or government contracts is a great example, and there's not really much we can do. I still say, especially if you qualify for my services, please reach out, because at a minimum you should understand the contract. Even if they say, this is it, take it or leave it, still you need to understand the rights, how you can terminate it, what the deposits are, what to do if certain events arise, and make sure that you're truly comfortable with it before you get kind of sticker happy and say, oh, I'm just going to sign it. I got this great new job. And I've certainly had a lot of clients that actually were told that they weren't allowed to change anything in a government contract. And we were able to negotiate some things that were just absolutely blatantly one-sided to the government. You probably won't be able to present your own contract. You might be able to present your own NDA, something like that, but likely with government agencies, they have gone through a huge bureaucracy process to get this template contract, and to have anything changed in it isn't like one person just says, oh, that's reasonable, let me change it. It has to go through this huge hierarchy of steps to the city or county attorney and several people, and it will take months. And obviously business doesn't move that slowly. But if it's something really obvious and it's really one-sided to the government and really unfavorable against you, and it's just too much to ask for, I have been able to negotiate some things like that away. So yes, legally you have the right to present your own contract, but in governments, it's just unlikely that they would ever accept it, just because they have so many people that need to approve that. But again, I do recommend understanding the contract, and then if there is something that is very unfair to you, pointing that out and just saying, all I'm asking for is this to be changed or removed. So coming up with smaller changes rather than a whole contract would be a lot easier to get those changes.
Okay, great. I know a lot of our listeners here are people that really do business with the government, so that was a really good question, and thank you for answering that. I have another one. It's pretty simple. I have a home-based business. Do I need to put my home address on contracts, or can I use a P.O. box? So that's a very simple one.
Yeah, you can use any address you want. You just want to make sure that in all contracts you enter that's the address listed for notices. And then I also want to briefly mention sunbiz.org, sunbiz.org. Anytime you have a change in your email or your address, you should really be updating it on sunbiz.org, because when someone needs to find you and they search your business in the public records of the state of Florida, whatever information you have registered there is where they're going to send notices. And you want to make sure that that's up to date. You're required to file what's called an annual report that was just due a couple of days ago with the state every year, updating that information. But if in the middle of the year something changes, you're going to want to update that. But then again, for contracts, if you want something to go to a P.O. box, you can absolutely use that as the business's legal address for notices.
Okay, very good, very good. I have another one. Let's see. Oh, yes, we still have time to answer more, correct? Okay, so we have another one. It says, we are an IT consulting business and work with 2 other entities based in Virginia. What is the best course of draft and partnership agreements, since our business is based in Florida and our partners are in Virginia? Also, how do I get in touch with someone from well, that's you. They want to know how they could get in touch with someone, but in the Tampa area.
Sure. So for the first question, which I'm going to kind of relate it to a broader topic, if you have the opportunity to draft the contract, I always recommend that, because you can always put things that are slightly more favorable and protect you better than the other party. When you don't have an attorney, that gets a little more complicated, because most people don't want to actually pay for an attorney to draft it. But if you, especially client template agreements, are a great idea. Even if you find them online and can tailor them to you, if you can't afford an attorney and don't qualify for our free services, make sure that you're choosing the first term. It's kind of like an opening offer. It's just a little more favorable to you and sets the bar towards you. And then so as it relates to working with partners outside of the state, I would make sure that you're you have a partnership agreement that adheres to the laws of the state of Florida and make it a Florida partnership. So when you enter a partnership, you have to actually decide where the partnership is quote unquote incorporated. You can incorporate it and should, but oftentimes people don't. But you want to make sure that the laws that you're comfortable with, even if you're not experienced in the law, especially partnership law, you know more than you think. You probably want to make sure it's Florida partnership agreement, and so that if anything happens, you're litigating that in the state of Florida and not in Virginia. And that might not be something that your partners in out of the state agree to, but at least that's what I would recommend if you can, making sure it's a Florida partnership agreement. And one way to make sure that happens is you draft the initial partnership agreement and present it to them, making it a Florida partnership agreement.
Okay, great, great.
And then I'm sorry, I forgot the second half. And for the Tampa contact information, there is a website that I'm going to read in just a second. So for anyone that is out of this Broward, Lee, or Collier County, there's a website you can go to and fill out an intake form, and they will set you up with an attorney, whether it's Tampa, Tallahassee, the Keys, wherever that may be. And that website is...
And certainly that's something that I can pass on to them as well.
Perfect. It is www.fl, like Florida, so flcommunitydevelopment.org. flcommunitydevelopment.org for anyone out of this area. And you'll do an intake form on there, and they'll set you up with an attorney in your relevant area.
Okay, great. I have another question.
Sure.
Could you dive in a little bit more into the insurance aspect of contracts, such as who is responsible for holding insurance, especially in the case of hiring independent contractors or COIs?
Insurance is very specific. My answer as an attorney is that you're always going to want as much as you can get, but in the real world, that is very difficult to accomplish because insurance is expensive. So most times my independent contractor agreements do require that the independent contractor holds some kind of insurance. But I also, even if it's not in my contract, the employers also will have some kind of independent contractor insurance that will cover the work that independent contractors do. So in a perfect world with a fair amount of funds, it is truly best practice to have both insured, because you never know what's going to do wrong. You honestly don't know who you're hiring and what kind of mistakes they will make. And you want to just make sure that when you put your head on the pillow at night, that you are protected if something goes wrong. So I advise for both the employer and the independent contractor to have that insurance. But again, depending on the specific situation, really I can't even think of a specific situation where it wouldn't be both, but it's very reasonable to ask your independent contractors to hold some kind of general liability insurance as well.
Okay, wonderful. There are a few more questions. I'm going to read one or two of them, and then we're going to wrap up, or if you have a little bit more time, I'm not sure. So let's
unlimited time. So whoever wants to stay on longer, I'm happy to answer questions until we run out.
Wonderful, wonderful. This is a comment. I think there's a question comment as well. It says, "Hi, Callie. Thank you for all the explanations. I'm planning to apply for government contracts, but I have my business in home, specifically the production process. We have some machines there, so I would like to know if I legally have issues with this."
And can you restate the question? It's going to be a government contract.
Yeah, they're planning to apply for government contracts. Mm-hmm. They have their business at home, mm-hmm. and specifically the production process, I guess they're asking mm-hmm. about. We have some machines there, so I would like to know if I legally have issues with this.
I'm not sure if they could clarify what the question is, what they mean with machines and production. Mm-hmm. But especially if you're an independent contractor for the government, Working at home is absolutely not a problem. They probably expect that.
I believe the question is that they have a home-based business and they have machines at home, and they're trying to apply for government contracts. And if they're wondering if there are any legal issues that would be there because they have their equipment at home.
Right, their own personal equipment. And so it should spell that out in the contract or in the offer for people to try to get the government contract, exactly what equipment they're expected to use. Oftentimes, even if you're an independent contractor agreement, and particularly with the government, they may provide their own equipment because you may be dealing with very sensitive and confidential information. So it's not really a legal issue, but it should say, in the listing, or you should confer if you can use your own equipment.
Okay.
But that should be different for each individual employer.
Okay. Got it. Thank you. There's another question. If on the contract it states reasonable time, how will the courts view it, and what does it mean? Or should an actual date be stated?
It's much better for a specific date to be stated, but sometimes when lawyers and anyone uses the word reasonable time, because coming up with a specific date to have to enforce something by is really difficult to determine. So if put in a date where you can for sure, because the more clarification, the less likely any conflict or litigation will result. However, if you can't come up with a date and something needs to, they need to get something in a reasonable amount of time or finish a project within a reasonable amount of time, and that becomes an issue of conflict and a judge needs to decide what's reasonable, he's going to look at all of the facts and circumstances. So if it's construction and a hurricane hit, and you may have told someone that the project would take 6 months and it ended up taking 8 months because a hurricane, postponed things. The judge is going to look at, is that actually reasonable? Is it reasonable that it would take 2 more months? It might make more sense that it took 2 more weeks, but 2 more months, I'm not sure if that's reasonable. So they'll look at all of the specific things that are relating to exactly what delays there were and why it was unreasonable. So just as you would, just as a plain person, look at the situation and find out, was that actually done in a reasonable amount of time, or were there unnecessary delays? And especially, did those unnecessary delays cause me any kind of harm?
Okay, great. Here's another one. Without an internal operating document, state law determines everything. Can you please elaborate a little more on that?
Sure. So if you're a sole proprietor, the only one in your business, or a single member LLC, only one person in the LLC, or one person in your corporation, these are still, an internal operating document is still important, but it's not nearly as important as if you have more than one person involved. If you have more than one person involved, you likely have a meeting of the minds of how this relationship is going to work out. But you really want to take the time to put pen to paper, because if you don't write it down in either your operating agreement for an LLC, your bylaws for a corporation, or your partnership for a partnership, then Florida law might fill in that gap for you. A judge isn't going to say, hey, what did you actually think when you entered into this legal relationship in this LLC, for example? They're going to say, do you have an operating agreement? Because that operating agreement should spell out who put in what money, who is doing what, who gets what payout, how the taxes are paid, things like that. And if it's not actually written down, what I mean that Florida statute fills in the blanks is that it's probably going to assume if it's 2 people, a 50-50 partnership, or if it's 3 people, 1/3 each, that everyone has the same voting rights, law will assume. But maybe someone's just an owner, or an investor, and they don't actually get to manage the business on a day-to-day basis. You want to say who's actually just an owner and who's an owner but also gets to transact business on behalf of the company, such as entering into contracts or a lease or taking a loan out on behalf of the business. So it's a lot of things that if you don't think about, judges, it's just too overwhelming for them to go through each thing. So whatever makes the most sense under law, they're just going to impose on you unless you actually write it down. So say that there's 4 people in a partnership and one person gives most of the money. Under law, they'll interpret it that it doesn't matter that that one person gave most of the money, that all of the partners split the profits and losses equally. And that's probably not what that person who put in the most money meant to do. So you just want to make sure whatever it is that you're thinking, how a partnership, whether it's a partnership, LLC, or corporation, or however it's going to work, how it's going to be managed, who pays what taxes, who's in charge of doing what. Does every single person get one vote, or does someone, because they put in a lot more money or provide a lot more work for the business, do they get more voting rights? Say you have a business and you put $4,000 in and your partner put $1,000 in. If you don't actually document that, the law might treat it as that you both put the same amount of money in. And that's not true or really fair, but unfortunately that's just how it works. So you just want to make sure that you have an internal document agreement that details all of those things so that law doesn't fill in the holes, if that makes sense.
Sure, absolutely. Very good. This has been very good. I am pretty sure that people learned a lot. I am really happy to have you here. And, you know, let me see, there are no more questions. So I think that we've pretty much answered for the majority, for the most part, in terms of what we really wanted to accomplish here, just to really bring our small businesses in South Florida some legal advice. And we do look forward to you joining us again on the 23rd at 12. Again, we'll be do Legally Speaking once more, and it will be at 12 o'clock. And so we'll see you at that time on the 23rd, July 23rd. So that's 2 Thursdays from now. Callan, do you have anything else to say at this point? Just so that we can, as we're wrapping up, any advice or any last words for our viewers?
On this topic, again, as I started, always making sure something is in writing, even if you feel comfortable with the party that you're entering into an agreement or that you have a legal relationship with. Just put it in writing and save yourself the time and the stress that when something goes wrong, because I promise something will go wrong, and you don't want to have to argue something that's in your head and not actually down on pen and paper. And I really enjoyed being here. I hope you all have some valuable information you'll take to make your businesses more successful. And I look forward to seeing you back here in 2 weeks for our next topic, which I believe is about different business entities. So the difference between a sole proprietorship, a business, or a partnership, an LLC, and a corporation, and then the different liability protections with each.
Yes, absolutely. And, that's good, because a lot of times we have businesses, we form LLCs or S Corps, or just have a sole proprietorship. And we really need to take a look, depending on the direction of where your business is at that current time. And now is the time to really do so, to take a look at your business to see where you're going from here. So that would be a great topic. I look forward to having you again, Callan. Everyone, thank you for joining us. We will see you on the 23rd. Thank you. Have a good one.
Thanks, everyone. Bye-bye.